Most people involved in a car accident do at least one thing wrong, not because they're careless, because they're panicking, they're in pain, and nobody ever told them that what you do in the next 10 minutes could determine everything that happens legally over the next 10 months. The accident itself isn't always the problem. What you say, what you don't document, and what you agree to afterward. That's where cases are won and lost. And the rules are not what most people assume. The first thing most people do after a collision is get out of the car, look at the damage, and start talking. That's natural. But legally, that conversation is already part of the record. Here's the core principle. Anything you say at the scene can be used against you. You don't need to be under oath. You don't need to be in a courtroom. A casual, "I'm so sorry, I didn't even see you," to the other driver can be treated as an admission of fault. Insurance adjusters are trained to look for exactly these kinds of statements. So is opposing counsel. What you should do instead is keep the conversation factual and minimal. Check that everyone is okay. Call emergency services if anyone is injured. Exchange information. Name, contact details, license plate, insurance provider. That's the exchange that legally matters. Don't discuss who was at fault. Don't speculate about what happened, and don't let the emotional pressure of the moment push you into saying more than you need to. One more thing. In most places, you are legally required to remain at the scene of an accident involving injury or significant property damage. Leaving, even if you think the accident was minor, can escalate the situation into a criminal matter. The threshold for what counts as significant varies by jurisdiction, so when in doubt, stay. Here's something that surprises people. Photos taken at the scene are often more valuable than witness statements. Memories fade. Witnesses become unavailable. But a photograph of the exact position of the vehicles, the road conditions, the weather, the damage, the tire marks, the traffic signals, and any visible injuries. That photograph is time-stamped, locked in, and extremely difficult to dispute. Take more photos than you think you need, from multiple angles, up close and from a distance, before anything is moved. Get the other driver's full insurance information, not just the company name, but the policy number and the insured's name. If there are witnesses, ask for their names and phone numbers. If there's a police report filed, get the report number. That report becomes part of the official record and can carry significant weight in any dispute over who was responsible. Document your own condition too. If you feel any pain, stiffness, or disorientation, even mildly, note it. Photograph visible injuries as soon as possible. Some injuries, particularly soft tissue injuries like whiplash, don't fully present until hours or days later. Courts and insurance companies are well aware of this, but they also know that gaps in documentation make claims harder to support. If you drive away from the scene with no photos, no witness contact, and no police report, you've handed a significant legal advantage to whoever disputes your version of events later. Reporting an accident to your insurance company is usually required under your policy terms. Failing to report promptly can actually give your insurer grounds to complicate your coverage. So you do need to make that call. But there's a difference between reporting the accident and giving a recorded statement. Insurance adjusters, including adjusters from your own insurance company, are evaluating liability and exposure. That's their job. When they ask you to give a recorded statement about what happened, you have the right, in most cases, to decline until you've had a chance to speak with a lawyer. This is especially important if the accident involved serious injuries, significant property damage, or any ambiguity about fault. Be particularly careful with the other driver's insurance company. They do not represent your interests at all. Their goal is to minimize the payout. If they call you quickly after the accident, and they often do, they may be attempting to get you on record before you've had time to process what happened or understand your rights. You are generally not required to give a statement to the other party's insurer, and anything you say in that conversation can reduce or eliminate what you're owed. Most people assume fault works like a light switch. Either you caused the accident or you didn't. The legal reality is more complicated and more consequential. Many jurisdictions, fault is assessed on a spectrum. If you were partially responsible for the accident, your compensation may be reduced by your percentage of fault. Some systems go further. If you're found to be more than 50% at fault, you may not be entitled to recover anything at all. The specific rules vary significantly depending on where you are. This is why the details matter so much. The other driver ran a red light, but were you speeding? You were rear-ended, but did you brake suddenly without cause? These nuances feed directly into how fault is distributed, and how fault is distributed determines how much you can recover. Insurance companies know this. They're not just evaluating what happened. They're looking for any basis to shift a percentage of fault onto you. Documentation, witness statements, police reports, and the consistency of your account all affect where that number lands. Even if you feel fine after an accident, see a doctor as soon as possible. This is not about being dramatic. It's about the legal gap that opens up when time passes between an accident and a medical record. If you don't seek treatment and later discover an injury, or develop pain in the days following, it becomes much easier for an insurance company to argue that the injury wasn't caused by the accident. That gap in the timeline is a legitimate tool of dispute, and it's used regularly. A medical visit creates a contemporaneous record. It connects your physical condition to the event in a way that's very difficult to challenge. It also ensures you're actually okay, which matters more than any legal strategy. If you were injured and accepted a quick settlement before seeking medical attention, or before understanding the full extent of your injuries, you may have signed away your right to additional compensation. Most settlement agreements include language that closes the claim permanently. Once signed, that's typically final, regardless of what you discover later. Not every accident requires a lawyer. A minor fender bender with no injuries and clear fault usually resolves through insurance without legal intervention. But if there are injuries, disputed fault, significant property damage, an uninsured driver, a commercial vehicle involved, or an insurance company that is slow to respond or undervaluing your claim, these are situations where legal representation changes the outcome. Personal injury, lawyers in most countries that follow a common law system work on contingency for car accident cases. That means they take a percentage of the settlement rather than an upfront fee. This removes the financial barrier that stops most people from seeking help. It also means the lawyer only gets paid if you do, which aligns their incentives with yours. The time limit for filing a claim, known as the statute of limitations, varies by jurisdiction, but it is real and it is enforced. Waiting too long, even if your case is strong, can bar you from pursuing compensation entirely. If you're unsure whether your situation warrants legal advice, most personal injury lawyers offer free initial consultations. Use it. A car accident is already one of the worst moments in an ordinary person's week. The legal side of it shouldn't have to be another one, but the uncomfortable truth is that the legal outcome often has less to do with what actually happened and more to do with how well it was documented, how carefully things were communicated, and how quickly the right steps were taken. You don't need to become a legal expert to protect yourself. You just need to know that what you say matters, that what you document matters, and that the window to get things right is shorter than most people realize. The law isn't designed to be confusing, but it does reward the people who understand it and quietly penalize the ones who don't. This video is for general educational purposes only and is not legal advice. Laws vary by country, state, and jurisdiction. If you're dealing with a specific legal situation, consult a qualified attorney in your area.